Dear friends, in the last two lectures, I was discussing about the writ petition dismissal before their lordship single judge, and also the case went through division benches, 3 division benches, and finally got dismissed. Now I have to talk about the review petition that I have filed. But before coming to this review petition, we need to critically apprise what exactly has happened and what were the reasons for dismissal of this writ appeal. How we should have handled it. This is actually, you may realize, I am a very ordinary and inexperienced person in law, but I have a great commitment to succeed. So, entire thing has happened over a period of 1 year. The single judge dismissed this petition in April 2012, and then finally the finality in the division bench, it took place in April 2013, a period of 1 year. So a constant analysis of mine gave me some knowledge which I wanted to share it with you. Ever since the case was dismissed, I immediately went and found out the order. In that order, basically their lordships have taken the stand that this is a matter concerning the expert's domain, because education. So the court should not interfere in those matters. That was basically the judgment. Entire proceedings are on the website srinivasatimes.com. You can have a look at it. So I was really disappointed, but then I started analyzing the issues. The first thing I asked the question is that the learned judges gave me a lot of time. They heard the matter with great patience. So I started critically analyzing the reasons, what could be the likely reasons for failure. And I have learned certain lessons which I want the young lawyers to take it as an input. First question I asked myself is that the learned judges heard me with great patience and with great concern, everything they have read. And if they wanted to dismiss, they could have dismissed straight away. So I thought, let me analyze what I have done. What is this writ, concept of writ? So in my writ petition, if I see my arguments, the matter, I never argued till then, because when the matter came before the learned Chitra madam, their lordships took a stand of mine, so I have nothing to argue, I just sat. So their lordships came to the conclusion that this must be published. And then the other side lawyer also admitted that there were a lot of mistakes. In the second adjournment, the lordships have asked them, what did you speak to the Institute of Chartered Accountants? Then they said, yes, we spoke to them. The Institute also agreed to some modalities will work out, Lords. So she was very much happy. So I thought I have done a mistake, because the bench has come to the decision in favor of me. But I could have waited for some time. When you know the outcome, I could have waited. Because the learned judge, it was a specially ordered case. That means the same judges have to hear. So I have done a big mistake where I could have won the case. I lost it. It's all because of me only, because I applied to the Chief Justice to post it before some other judges, because the learned judge was in Madurai. That should not have been done by me. But then I felt more than that loss, I got an opportunity to present my case before the bench of the topmost judges, the top judge of this state of Tamil Nadu. So I thought, let's not worry. First thing you should learn in law when you are a lawyer, pleading. The first question itself, I call it as not arguments but pleading. As I already told, that you were not able to convince their lords, that's all. And so what was the reason? So let us understand that is what I thought. So when I went back, what all that I argued? I was arguing, point number one is that the Institute of Chartered Accountants of India has been doing injustice to the students, large section of students, and they themselves don't know the subject on which students are being evaluated. So that I wanted to establish, it was the lordships were convinced. So I came to the conclusion, I got the best judges in the bench, but then they have not appreciated my case. So what exactly was my arguments? What is writ of mandamus and how I should have argued was my latest thinking. Next. So I went through all the books. Basically I went through the MP Jain, and thereafter related cases, everything I have read. Then I came to the conclusion, I emphasized on facts. But I could not give them a convincing reason about my status, locus standi, and I was not able to convince them how my fundamental right has been affected. I am going on talking about larger interest of students that is being affected. Then it is for the students to come before them. So they are very clear. I thought that so far as the Institute of Chartered Accountants of India is concerned, their examination system is fairly good compared to the Bar Council and others. So they thought, today he is telling all the time, these are all the mistakes, this is what they have done. He wrote a letter, they have not published it. So he wants the court to give a direction. So this is an expert domain. Therefore, how the court can come into the picture? Second point was raised by their lordships, Vasant Kumar, was that when there is an article, regulation which prohibits revaluation, then that's all, we cannot interfere. That was also a valid point their lordships raised. So I tried to convince them on 39.4 regulation which prohibits revaluation by citing this Pravas Ranjan Panda's case and also Sahiti versus NTR University, wherein student is not competent to ask for revaluation. That was the judgment of Supreme Court. And NTR versus Sahiti, the Supreme Court again said that if there is a reasonable proof to show that carelessness on the part of the examiners, then revaluation must be considered. So then I tried to convince that it is a mind judgment, mind will get into bridge both things. That was I felt a valid point. But then their lordships have not appreciated. Fair enough. So, in other words, I must have convinced their lordships. In fact, if you come to the question now, if I am in this position now, I need not have wasted so much of time, of the valuable time of the court, because I should have only concentrated on one thing to win my case. What is that? In Andhra Pradesh, state of Andhra Pradesh versus Jaiswal's case, Honorable Supreme Court has said very clearly that when a division bench comprising of say 2 judges have come to a judge's opinion about a particular case, then suppose if the case comes before another bench of equal number of judges, then they should not take any view against that previous judgment. This is because there should be stability in the law. Article 141 of the Constitution, stare decisis, says that there should be consistency. You should know if you go like this, you will win the case. So in my situation, it has become such that the division bench has come to the conclusion, which I have emphasized in the arguments. But I don't know about this AP Jaiswal's case. So I should have started my arguments clearly saying, this is the case. The division bench have already came to the conclusion. Then because their other side lawyers are there, and in a writ jurisdiction, I found, at least my experience is limited to writ jurisdiction, even the advocates are of high caliber. They follow the law to a larger extent in letter and spirit, especially very senior lawyers. They will be strict on the law. So I could have emphasized before their lordships that this is what happened. If it is not happened, let him deny. Once I was able to establish, then I could have told their lordships that already division bench has come to a judgment, and therefore in case your lords are going to take a opposite view, then it should be referred to a larger bench. So that could have solved the entire issue. Violation of Article 141. But then I don't know anything at that point in time. But then I am working very hard to learn the subject. Then I for the order copy to come, and therefore I thought I'll go for review. Before you go to the Supreme Court, let us see, once again I'll get experience, because that's the first time I was arguing before their lords, and they were kind judges, at least they will hear me. In review petition, it's bound to be dismissed, that is very clear. So therefore, I thought I'll give one more chance and then go through that, how I can argue. Review petition is, scope is very, very limited. You cannot again bring arguments which you have not argued. So the scope of review is very clear. Whatever you have argued before their lords, and if that lords have not considered those arguments, or if there is an error apparent on the face of the record, then review may be considered. It is again a purely discretion. Very rarely review petition is allowed. So I moved a review petition after I got the order copy, and then it came. Their lords told me, Chief Justice, that we will hear you on Friday when Paul Vasant Kumar judge who was in Madurai will come. So therefore, on at 2 o'clock the first case is mine, and the chief was listening, and Paul sir was. Both I gave written arguments. First, my contention was this. This is what how I argued. So first and foremost, I refer to the judgment, wherein the judgment says that there are three. That I have asked the manager, the institute, as a matter of right to publish this, which is not maintainable. That was the single judge opinion, which division bench also reiterated that. So I said, my lords, what is judicial review? Judicial review is basically testing the legality, the decision making process. The judicial review is basically challenging, testing the decision making process against the touchstone of law. So I am not talking about the decision. Decision is left to the administrative body to publish or don't publish. Now I am saying, lords, the judgment, the decision making process followed by the administrative body is violative of Article 19(1)(a) and 14 of the Constitution. This is my contention, lords. Then immediately Chief Justice said yes. He was very receptive, kind. So at least I was able to speak well. Then I said, how my rights have been affected. All that I am asking, my lords, 19(1)(a), I wanted him, the cause of action arose to me because they have published one-side view to the students. I am a professor. I am a professor of 25 years specialization in that subject, and the publication talks about saying that examiner's view says that students have not understood this question, that question, lots. Then I found the examiner has not understood anything. He have done mistakes and ruined the lives of the students. Therefore, I have written an article pointing out the mistakes committed by the institution. And they have not replied. That means they have admitted. And therefore, I have a cause of action. The Manu Bhaisha's case very clearly says the state instrumentality must publish this genuine criticism. In case you are not willing to publish it, give reasons. You don't give reason, you don't publish, then that's violative. That was the issue. The chief was he agreed. He nodded with this thing. He nodded and he was in agreement with that, is what I felt. Then, my lords, can I brief the Professor Manu Bhaisha's case in short? He said, yes, you proceed. Then I said, my lords, Professor Manu Bhaisha is an expert in life insurance. He did some research. then he came to the conclusion that LIC is playing a fraud on the nation. That was also published in Hindu. Thereafter, there was a rejoinder published by LIC. That was also published in Hindu. The matter closed. Now it went step further that LIC published it in the Yoga Kshema, published by their in-house journal. Only the views of the LIC. So Honorable Gujarat High Court Division Bench came to the conclusion, here is a situation, you want everything nice, what is palatable to you is published immediately, you are publishing. A honest criticism, you are not willing to publish it. After all, you are talking to some audience and you are using the money of the public. Therefore, the public are entitled to know both the views. And it is left to the public to decide the fairness of the opinions expressed. Therefore, and it was very clearly explained that Article 19 is a freedom code, Article 21 is life code, Article 14 is equality code. When you are interpreting this Article 19, 21 and 14, you have to test it against very liberal interpretation. Then I tried to explain immediately. Paul Basant Kumar Judge asked me, what is your locus standi? You please tell me that. You are not convinced us on that. That's what he told me. Second, he told, you see, you are arguing as if it's a new case. The scope of review is very limited. He was kind enough to tell me that. So I have showed him that Ranbir Singh, a state of Bihar, Honorable Supreme Court said that no doubt, mandamus is to be used when they establish that there is a legal duty on the state instrumentality and a corresponding legal right on the petitioner. That is at the lowest level. But when it comes to a public interest is involved, here you are failing all the students who are writing the exam indiscriminately. Then there is a larger public interest, injustice is proved. When there is injustice proved, then you have to be very flexible. Mandamus has to be used in that case, ignore all the other things and correct the justice. That is where you cannot narrowly interpret the mandamus. And Chief agreed to my view on this. Then I told their lords, you see a situation that has developed where students are failed by getting 1 mark less. The CA Institute enjoys like this. And when a student gets 39 and fails, he has to write all the other papers even though he has passed. So there is a tough valuation, at least they claim to be. And it is proven that they are not competent. They are claiming they are world class, but nobody has given them any certificate. And they are not able to answer the questions raised. And therefore what has happened lots is that students who have done well, they failed. And the students who have not done well, they got ranks. So therefore you are treating equals as less than unequals and unequals as more than equals. Therefore there is a violation of Article 14 of the Constitution, which is the rule of law. Their lordships agreed with me. That point also he said, yes, you are right. He was very keen reader, a great judge, soft and dispassionate. I mean, is very. He gives impression, in spite of fact, he is very knowledgeable. He feels like learning every time. I was surprised. An ordinary person like me, I think he appreciated me. Is my feeling. I got confidence. Honestly, it is a great experience for me. Even I have lost the case, I learned a lot in that. The third one was the judgment. What happened? The CA Institute always uses all other things. They have taken a disciplinary action against me for why they don't know. That has been already stated by the Madras High Court. And they started saying that I have got a grudge against the institution. That is why they have done all these things. Now it is proved that they are 100 crore scam against the CA Institute. The CBI inquiry has been is going to be ordered. So therefore now the cat is out of the bag that they are most inefficient and corrupt. But then that time I was also not able to convincingly speak on that. So their lordships have felt, they mentioned that point. So I raised the issue. Here is the institution is talking on something which is not concerning me. That is a subject matter of another case. And these people, in order to divert the attention of this honorable court, they are trying to bring this. And since I thought this is not concerning to this case, they should not have brought it. It is the violation of principles of natural justice, my lords, I said.